and welcome to We Are Not a Stereotype, Breaking Down Asian Pacific American Bias. Thank you for being here with us for this inaugural series of talks created for educators by educators. My name is Andrea Kim Neighbors, and I'm the Manager of Education Initiatives at the Smithsonian Asian Pacific American Center in Washington, D.C. We could not have made this talk and series possible without our brilliant speaker and educator, Robert Kim, who you'll be hearing from shortly. We're grateful for the space they're creating with us to talk about how Asian Americans, Native Hawaiians, and Pacific Islanders have shaped the legal landscape. As Bob and I are in different parts of the United States, we want to begin this talk acknowledging the people and lands our speakers are currently on. We would like to acknowledge the people of the land, past, present, and future. The Piscataway, the original stewards of the area commonly known as Washington, D.C., where the Smithsonian Institution is located. The Lenape, the original stewards of the area commonly known as New York City, where Bob is located. We also want to take a moment to recognize those nations who are not acknowledged, yet occupy or have occupied the lands we teach on. I would like to take a moment as well to thank our sponsors, since the series would not be possible without their support. This project received federal support from the Asian Pacific American Initiatives Pool, as well as support from Expedia. We would like to thank them for sponsoring this series and for making this learning opportunity available online for educators across the country. I'm now pleased to introduce Bob Kim, a leading expert in education law and policy in the United States and the author of Elevating Equity and Justice, 10 U.S. Supreme Court Cases Every Teacher Should Know, the co-author of the 5th edition of Education and Law, and Legal Issues in Education, Rights and Responsibilities in U.S. Public Schools Today. Bob has been a fellow with Rutgers University and served as a Deputy Assistant Secretary in the U.S. Department of Education Office for Civil Rights during the Obama administration. He was also a civil rights attorney at the American Civil Liberties Union and policy analyst at the National Education Association. Thank you so much for joining this talk, breaking down how Asian Americans, Native Hawaiians, and Pacific Islanders have shaped the legal landscape. And Bob, thank you so much.
Thanks, Andrea. It's so good to be here. So today's talk, and I'm so happy to be here with you all, is to talk about how Asian Americans, Native Hawaiians, and Pacific Islanders have shaped the legal landscape. And I'm hoping this will be as fun as we can have during these times and engaging, hopefully informative in some way. And just a little asterisk there, as you can see, I use the term Asian American, Native Hawaiians, and Pacific Islanders as one way of capturing the broader Pan-Asian, Pacific Islander, Native Hawaiian community. I recognize and respect that there's other terms that we could use to capture the community, but with your indulgence, I wanted to, we'll use that acronym for now and proceed with the conversation using that term. So moving on to the next slide here. The goals for today really are fourfold. One is to reflect on the importance and the impact of the US judicial legal system. Andrea and I decided we're going to do that in a kind of a fun and engaging way to sort of talk about, just go over a little, some basic lay of the, get the lay of the land around what the law is, and then talk about how our community has really impacted and shaped the judicial system. We're gonna then go into several really notable and interesting cases involving the AANHPI community. And I had so much fun looking at these cases, and they're just fascinating for different reasons. So I hope that you'll get something out of it too by doing a review of these really important cases in US history. We're gonna also be a little critical about the system, the US legal system. Not everything is perfectly as it should be. We don't necessarily agree with the outcome of many of these cases. We think in some cases, maybe the judges were wrong. In some ways, they might have been racialized or racist attitudes reflected in these opinions. So we want to be critical too, and not look at whatever comes out of these courts and the US Supreme Court certainly as sacrosanct, but be critical. And then finally, let's talk a little bit about how we can use cases and materials in the classroom as educators. I believe that the law is a treasure trove of different materials, source activities that are so educational in nature. I've always thought that the law in our country is shrouded in mystery, and It's only available to those who go on to pursue legal education. And that's really unfortunate because we all, as educators and as citizens, as residents of the country, as learners, have so much to learn from legal materials that why don't we do what we can to understand the law, make it more accessible to ourselves and to our students, and have fun doing that in the process. So those are our four main presentation goals for today. And then moving on to the next slide. And as we talk about the legal cases that will follow, I wanted to just put up some framing questions that might help us think a little bit. It might be useful to us as we go into talking about these cases and how to maybe questions that we want to think about as we're talking about these cases. So the first is, what is race? And how has race operated in the United States to the advantage of some versus others? So that's our first sort of framing question. The second question is, who is an American? What does it mean to be American? And I guess by the same token, who is a foreigner in our country? And so you'll notice that, as we talk about these cases, that there's some overlap here between race and citizenship or nationality. And that's interesting as well, that in some ways being American has involved a discussion of what racial group you come from and privileges afforded to certain people of certain races versus others. So that's our second framing question. And then the third question really is, what does racial equality really mean in our nation? And what can the law teach us about the unique challenges of AANHPIs in achieving equality? Should racial equality, for example, be tied to citizenship or a certain immigration status in our country? Should there be any difference in the way people are treated by race, by our government in this country, such as, for example, we'll talk about college admissions or being able to operate a business, or, the terms of confinement of people in our country, in our prison system or our immigration system. Should there be any difference in how people are treated by race? And then, a related question is, or should there be affirmative steps needed, and people might need to be treated a little bit differently in order to create a more equitable environment for all people, no matter what their race is. So a little difference there in sort of what racial equality might mean, depending on how we look at it. And also, certainly, how does equality relate to concepts of freedom and to do what we want or to express ourselves as we want on equal terms, no matter what racial background we come from? So those are some questions that we'll explore in terms of the meaning, the true meaning of racial equality. And then finally, I'm here, and I'm aware that we're here as part of a series that the APA Center is putting on and Smithsonian is putting on to sort of examine the issue of stereotypes of the Asian American, Native Hawaiian, and Pacific Islander community. And in preparing for today's webinar, it just really struck me that the cases that we're about to explore really do tend to either reinforce or counter common stereotypes about the AANHPI community. And I thought I would just sort of raise that, and it might be something that we think about as we talk about these cases. For example, the notion of the Asian American, Native Hawaiian, Pacific Islander community as being largely consisting of foreigners. How has the law contributed to this notion that we're not citizens, that we don't belong to this country? Has the law sort of afforded rights to the majority, the racial majority in this country, by denying rights to the minority? Or have we defined race in a way, for example, what it means to be white and therefore be privileged in our country? Have we sort of defined that legally by examining and sort of legally defining what is not white, including members of the AANHPI community? So it's a very interesting thing about foreignness. How has the law sort of contributed to that stereotype in some ways? certainly the model minority myth, we've heard about this many times, that Asian Americans in particular are the so-called model minority in this country. And we'll see how these cases in some ways defy that stereotype, right? Because they counter the notion that Asian Americans shouldn't even have legal problems because we're such a model in the community. Certainly, you'll see in these cases that we have complex lives, and that the cases, really involve rich disputes that and concerns of our community. In some ways, I think a little bit, you'll see that they defy this stereotype that there is such thing as a model minority status in this country. For sure, and one or two more stereotypes about the idea that AANHPIs are obedient and quiet people. We don't assert ourselves. We basically submit to what is happening to us. That is certainly belied by cases where plaintiffs who are Asian American, Native Hawaiian, or Pacific Islander have showed really remarkable strength and resilience and even defiance over things that were happening to them. So that stereotype certainly, I think, is challenged by exploration of these cases. And then finally, another stereotype that comes to mind is one that involves Asian Americans as being monolithic as a culture and as a community, right? So the idea that we're all similar. And even in the brief scan of cases, we can see how the plaintiffs and the people involved in some of these cases came from very different backgrounds and cultures, ranging from many different countries, many different languages and cultures, and many different stations in life, from being extremely lacking privilege altogether to maybe having a little bit more privilege and sort of asserting rights in a way that is very different from somebody who is absolutely lacking in all kinds of rights in our society. So the idea that we're a monolithic community and culture, I think is certainly challenged, and it's a good question to raise with students too, as you look at more than one case, is how are these cases challenging stereotypes about the AANHPI community? So it's a really great way to sort of talk about legal cases and what they depict about the community and how they challenge common perceptions about the community. So let's move on and talk a little bit about why is the legal system important in our nation? What is it about, and sort of why is it important for Asian Americans, Native Hawaiians, and Pacific Islanders to be part of our legal apparatus in the United States? And to do this, I think it would be fun, and the sort of the law instructor in me is compelled to give a pop quiz. And so Andrea, you're gonna be my sort of guinea pig audience here, I guess. So why don't we go through it, and maybe those of you listening can also take this pop quiz and see if you get the right answer. So let's raise the first question here in our pop quiz, talking about the law. So we're going to sort of civics education here. What are, Andrea, the 3 branches of government?
I'm excited I get to exercise my high school civics here.
Yeah, there you go.
I say the 3 branches are executive, legislative, and judicial.
Bingo, that is the answer there. That is absolutely correct. I wish I had prizes that I could give you here. So, we're getting into discussion about why the law is important and how it operates. And all 3 branches of government, and this occurs at the federal level, certainly the state and municipal level as well. You have the executive, which can be the president. It could be the governor in a state, for example. The legislative branch, which can include Congress or a state legislature that writes and passes laws. And of course, the judicial branch, which we'll be talking about the most today, which is judges, courts doing their thing. And just a note, law comes from all 3 places, all 3 branches. It's not just courts making law, but obviously the Congress makes laws, they pass laws that have to be followed. The executive branch can issue orders They can issue and write regulations that have to be legally followed by schools, for example. So law comes from a variety of different places, even though we'll primarily be talking about court cases today. So next question is, yeah, you're batting 100 right now. What is the top court? What is the highest court in the United States?
Oh, that would be the Supreme Court right here in DC.
Ding, 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 you are correct again. You are 2 for 2, Andrea. And so you could put up the answer to that there. And so, you know, most of the cases that we'll talk about today are from the US Supreme Court, which is the highest federal court in the land. And generally, as we all know, the rulings from the federal court, from the US Supreme Court, apply to all of the states. And so it's obviously definitely the most important court in the United States in terms of the breadth and influence of what it says. It's not the only federal court though, because you have appellate courts under the US Supreme Court, and then you have the federal district courts or trial courts, which in where full-blown trials can happen at the district level. So, you know, thinking about the federal system alone, many levels of courts, the Supreme Court being the top one, and that sort of level of hierarchy is replicated at the state level, where, you know, we'll talk a little bit more in a second. There's a whole separate state court system that's different from the federal court system. So, so yes, good answers. And let's go to the next question. It's getting a little trickier now. Is the Civil Rights Act of 1964, which is a federal law, is that an example of statutory law or constitutional law? And what do you think there?
Well, I'm going to guess statutory law.
All righty. Well, let's see what the answer is here.
Hey.
You are right again. And I know this, Andrea, is because you actually know these answers and are brilliant, and it's not because we shared the slides with each other. But yes, you're absolutely correct. The Civil Rights Act of 1964, as you could maybe tell from just the way that title is worded, it's a statute. So that's a law passed by Congress. Similarly, another famous civil rights law is like the Americans with Disabilities Act, or the ADA. It's statutory, so it comes from legislation. That's different from, like, let's say, a constitutional legal type of case or principles or law coming from the constitutional sense, like Brown versus Board of Education. You know, separate but equal is not an appropriate way to run schools anymore after Brown versus Board. That comes from a constitutional place and is different from a Congress-made or legislative body-made law. And you know, it gets a little tricky sometimes, because sometimes civil rights can come from both places. You know, the Voting Rights Act, that's a statutory, but it's really a statute that's meant to enforce the 15th Amendment of the Constitution with the right to vote, no matter what your race is. So sometimes there's overlap here between constitutionally derived law and statutory law, but and both types of law can contribute and do contribute to civil rights in our country, you know. So great. And then finally, let's see, do we have one more question, I think?
The second to last question.
Second to last question. Okay, 2 more questions. Does the right of Asian American, Native Hawaiian, and Pacific Islanders to equal protection under the law come from a statute or the Constitution? What do you think?
I think, you know, listening to what you shared earlier with the last answer, I'm going to say Constitution.
That is absolutely right, Andrea. You are batting 1,000 here. The equal protection is that language that all persons shall have equal protection under the law comes from the 14th Amendment of the US Constitution. And so it's really a constitutional provision. It's not to say that that equal protection is not guaranteed in some ways by a statute, you know, like we can say, going back to that example of the Civil Rights Act of 1964 that prohibits discrimination, or even in some ways like the ADA it guarantees in some sense equal protection for students with disabilities or people with disabilities. So as a principle, that can come from a statute or be enforced by a statute, or come from a constitution, federal or state. But the principle of equal protection and that notion, that basic protection, originally derives from the Constitution of the United States. So absolutely right. And then maybe this is the last question, which is, this is probably the most arcane, like sort of specific question, but what is a noun describing a court ruling that must be followed for future cases addressing a similar issue or matter? So it's a noun describing a ruling or a court opinion that has to be followed for future cases.
Ooh, this is a tough one. My brain is going way back into, think about this, years ago, high school civics. Thinking about, I don't know.
Yeah, it's not a word that sort of just is at the tip of your tongue, right, or in the top of your head, or whatever the idiom is there. Yeah. So I could just pull up the answer here, which is that it's called a precedent, right? And I know that most of us, maybe all of us, have heard of this term before. And I raise this question to sort of underscore why the law, and in particular judicial opinions, are so important, because they're not just one-off opinions that, yay, good for you, good for the parties in that case, whatever the result is, depending on the result, but no huge impact on the rest of the nation or in the future. Most cases, especially at the U.S. Supreme Court level, they establish some kind of precedent or holding that things have to operate a certain way in the future. So if the court says the government has to do X in this case, then it may be, if the opinion is written in the correct way, that the government also has to do X in the case tomorrow, or the next week, or the next year, if it involves kind of a similar situation or a similar issue. And so that's why it's so important for the cases, for cases to come up that involve not only, that involve Asian Americans, Native Hawaiians, and Pacific Islanders, and that they're decided correctly in a way that secures rights or clarifies how the community is to be treated in a particular case or involving a particular issue, because it really just affects, not only, as we'll see, not only the community, future members of the community in the future, but also maybe many others that in other communities as well, depending on how that opinion is written. So it really does have a lot. It's very important, especially at the top level of these court systems, for there to be representation, for there to be a proper airing of issues and disputes involving Asian Americans, Native Hawaiians, and Pacific Islanders. Mm-hmm. So hopefully, this question, these quiz items, like, we're having fun here, but they're starting to get us into the mindset of what are we talking about when we talk about the legal system. And then, so by way of summary, let's go to the next slide, and we can sort of showcase here that what we're talking about are different types of law, different areas of law, and different court systems. And so by types of law, I'm sort of talking a little bit about sources of law, maybe. And we've talked about the first two here, constitutional law, from that cases that talk about provisions in the US Constitution, for example. Statutory law, cases that talk about, like we'll hear a case that, we'll talk about a case that does involve the Civil Rights Act of 1964. So that's a statutory example of law. And there's other kinds of law too, contracts, a dispute in a contract, for example, or there's this other term called the common law, which I won't get into too much here, but it's really not constitutional or statutory. It has something to do with the way that I think about England here, like going back to pre-revolutionary days even, where judges kind of had to sort of settle a dispute and think logically about how they would settle some kind of dispute between two neighbors, or there was a personal injury, and the judges just said, well, we think this should happen, and that judgment sort of carried over from one generation to another. So it's kind of like judge-made law, which is different from something coming explicitly from a provision of the Constitution or a statute or a contract. So those are some types of law. And then on the right-hand column here, we have some general areas of law. And I think we'll talk about a little bit about all of these things today. We think about civil rights cases and what those involve. They involve, back to that principle of equal protection. A lot of civil rights cases involve the notion of securing equality based on race and other categories, securing equal protection. So that's a civil rights type of case. As opposed to a civil liberties case, which is, think about freedoms, the freedom to do what you want without the government interfering in your life. So we think about the First Amendment, the freedom of speech, freedom of expression, or from the Fourth Amendment, freedom from excessive search and seizure and intrusion into people's privacy. That's maybe thought of as a civil liberties type of concept. And then, even going beyond that, I only listed a couple of topics here in terms of areas of law, but you can see there are many, many areas of law that govern how we behave in our country. And this is really a nation of laws. Like almost every aspect of society is governed by one area of law or another. So it's tremendously important in how we really exist and live in our country. Is how the law defines, in some ways, how we should behave. And then finally, with this court systems thing here, I'm just noting, and we won't go into it very much, but we have a system of federal courts, state courts, and municipal courts. They're all autonomous in some level. And before I went to law school, I had no concept of like courts and what the differences were and so forth. A lot of the cases that we'll talk about today, since this is a nationwide webinar, are involving the federal court system. So we'll be mostly talking about federal court cases as for purposes of our discussion. But state courts can also issue very influential rulings in civil rights and involving our community as well. All right, and so now if we move to the next slide, we're just going to sort of preview again, a little bit preface what the cases involve that we're about to talk about. The question on the table here is most famous cases involving AANHPIs are in the area of what, and we'll sort of ponder that for a second. Andrew, you want to give a guess maybe before we put up the answer?
Probably immigration.
You are absolutely correct. And why don't we put up the answer there? Most cases do involve immigration and citizenship. I would say well-known cases, right? There's so many cases that are obviously not in this area. But I think that it's worth just thinking about, as we talk about judicial cases, why most of them would, in our community, would involve questions of immigration and citizenship. And if we think about it, it might be because this was the area. If we were a disenfranchised community, historically, that this would be the area most affecting AANHPIs. Starting from when members of the community started coming to the United States in the 19th century, and then following through the early part of the 20th century, establishing what our rights were as newcomers to the United States. So it may be that that's the reason why most cases involve this area. It could be because there was a desire to exclude members of our community from the country, to limit our visibility or presence. And so that desire by the government may have led to more disputes in this area. It could be that there was a lack of visibility in other areas for our community for so many generations. You know, you think about who works in corporations and who owns land and property. So there's so much law that's developed around corporations and property ownership. If we didn't have that, then we wouldn't have cases in that area necessarily. So it may be because of that there was an absence in other areas. But it really is an interesting question, and I think it you know, raises this sort of meta philosophical question about whether, you know, if we go back to that notion of Asian Americans as being foreign, that stereotype, you know, is the law just sort of reflecting that through these immigration cases, that there was just this notion of foreignness has always been an undercurrent of our engagement with the legal system, and so is the law just reflecting this perception of foreignness, or was the law really sort of doing more than that? Was it shaping and cementing in some ways this idea that the community is foreign through this series of many cases around immigration and citizenship? So it's just an interesting question, I think, that is, you know, maybe you'll notice as we go through these cases, a lot of them do involve immigration and citizenship. Let's go into a couple cases that examine this framing question of what is race? What does it mean? What does race mean in our country? Because as we know, it means different things in different countries. You know, what we think of, how we define each race is very different, you know, depending on what country or what society we live in. So the first case to do that that I want to raise is one involving Takao Ozawa. Mr. Ozawa was a graduate of Berkeley High School and UC Berkeley, and he was an individual living and working in Hawaii with his family for many years in the early part of the 20th century. So then if we turn to the next slide, we can see that Mr. Ozawa had a case that eventually went up into the United States Supreme Court. And this was really a case involving a Japanese American's attempt to gain citizenship. And this early 20th century case, it was the court that upheld a denial of Mr. Ozawa, even though he'd been in the United States, you know, for the entirety of his life, that they denied his citizenship because of the fact that the prevailing ruling was that immigrants could not become citizens unless they were, quote unquote, free white persons. And the Supreme Court defined that as being Caucasian. And that, you know, and they did the analysis here, Mr. Ozawa was clearly of a race that was not Caucasian. And so this is one early example where the US Supreme Court was affording rights of citizenship and all the privileges that come with citizenship based on a very defined racial classification. And if you were not a free white person, if you were not Caucasian, then you were not to become a citizen. And so it's an early example of how race is being shaped and defined, and whiteness is being defined according to these cases involving non-whites attempting to gain rights. And then we have this early example of the court saying, really defining race and defining what it means to be white in the United States. And then you can juxtapose that with the next case on our list here, which is the United States versus Thind. And here's a picture of Bhagat Singh Thind, who also applied for citizenship as an Asian American. And interesting thing is, and we can go to the next slide here with Mr. Thind, he actually was initially granted and then was later denied US citizenship. So he was granted citizenship from an earlier court, but he was denied citizenship afterwards by the US Supreme Court, which upheld the denial of his citizenship. And, you know, note that Mr. Thind was applying for citizenship right after the Ozawa case. So, you can imagine he was saying, okay, I can see you said that Ozawa was not white, but as he argued, I come from a background in India where, according to the prevailing science and ethnology studies, he classified, he could make a good argument that he was of a quote unquote Caucasian or Aryan background, according to the science of the time. And therefore he said, okay, I see what you said in the Ozawa case, but here I am coming to you, applying for citizenship, which affords incredible rights, and I want to be ruled as a citizen. And the U.S. Supreme Court again denied this Asian American the privilege of citizenship, saying that, well, what we meant by white was really people that are from a particular area, the British Isles and Northwestern Europe in particular. And so you are also not white, and therefore you also cannot become a citizen. And the interesting thing about this case was, you note if you read the case that the facts about Mr. Thind himself barely enter into the discussion of this case. It's almost like he's an invisible person. He's not even a real person. It really went very quickly into this justification about how Thind wasn't white, and was also very racially tinged. Frankly, when you look at the opinion, they were talking about sort of notions of people coming from different areas around the world, and really sort of made distinctions based on what we would consider today very racist descriptions of people of different parts of the world, in coming up with its conclusion that no, you as a South Asian man are also not white. So these are two early cases which kind of show how race and whiteness in particular are being defined, and how Asian Americans are being shut out of citizenship with an explicit race-based justification. And then as we go to the next case, we want to, and this next string of cases, we're really going to be talking about the second framing question, which is, who is an American in this country, and what does it mean to be American? And the next couple of cases are very influential in this regard. And you'll notice that we're talking about some early cases and then some more recent cases as well. So the first sort of case that I want to bring up here is a case all the way back, again, to the late 19th century, the Chae Chan-ping case, Chae Chan-ping versus United States. This took place shortly after the passage of the Chinese Exclusion Act. And as those of you who have studied US history and immigration history know, the Chinese Exclusion Act was the first law implemented in the US that prevented all members of a specific ethnic or national group from immigrating to the US. So it was, a very explicit racially exclusionary law passed just a few years before this case. Now, what happened in this case was there was an exception to the Chinese Exclusion Act where certain Chinese laborers could, if they went overseas, they could come back to the United States and still be allowed back in the United States. But then, and so Chae Chan-ping did that. He was in the US as a Chinese laborer for many years, and then he decided to visit China, where he was originally from. And in the process of, while he was visiting China, another law was passed called the Scott Act, which sort of closed that little loophole under the Chinese Exclusion Act, saying that, he could come back to the United States lawfully. It said, nope, they're not allowed back anymore. And so he was basically barred re-entry to the United States due to the passage of the Scott Act in 1888. And so the question was, what should happen to Chae Chan-ping? And so what we see here is that the Supreme Court upheld the denial of his reentry to the United States. Again, sort of stating very forcefully that, let's be clear here, Chinese laborers are not citizens of the US, they are aliens, which is a term that has been used for generations to describe immigrants in the United States. They're aliens, and therefore they can be excluded from the country. And this exclusion under Chae Champing of laborers affected thousands of Chinese laborers who were working in the United States at the time and were just not allowed back into the country. One important thing about this case is that it really was a foundational case to establish this notion of plenary power by the federal government to really control immigration policies. States can do very little to influence this area of immigration. It's really a federal government power, and it's an area of law that most of the constitutional provisions that you would think apply to citizens, many rights that we have, they don't apply to the same degree or even at all, as we'll see in one or two cases later on. They don't apply to the immigration field or to immigrants to the same degree as they apply to citizens. And this case was one of the real foundational ones to establish this awesome federal government power in controlling who enters this country, who is denied entry, and what rights they should have as immigrants. And then the next case that we're going to turn to is all the way over to almost the current moment. This is a case that was decided last year by the Supreme Court, called Nielsen versus Preap. And Moni Preap was a legal permanent resident whose parents were from Cambodia. He was born in a refugee camp, actually, and he's lived lawfully in the United States since 1981. The context is, and I put this next to juxtapose this with the Chae Champing case. They both involve non-citizens to the US. They both involve Asian Americans. The context is a little different here, obviously, where we're talking in the modern context that Preap was a legal permanent resident and was convicted of some criminal drug offenses in the United States, which subject immigrants, depending on what the offense is, to removal from the country or deportation. And so the issue here was that the terms under which Preap can be detained under a federal mandatory immigration detention statute or law. There was another aspect of this case which was interesting, which is that, he was convicted of these drug offenses, but then went years after that without being detained and was living, I think there were arguments from his lawyers that he was rehabilitated, he had been law-abiding, and many years went by. He was a full participant in society. But then many years later, he was then detained by immigration officials to enforce this statutory provision. And the US Supreme Court held in this case that the government can detain immigrants subject to deportation without any hearing on whether he was a flight risk or is a dangerous person. And this is very different, obviously, than a citizen would be treated. There's usually a bond hearing. You can't, depending on the crime, there's a right to a hearing and a determination made whether you should be released pending your trial or pending a conviction. It's a very different situation in the immigration world. And I think this case was one that was pretty important and very recent in sort of limiting the rights of immigrants to a hearing pending their deportation or removal from the country. This area is also really, I think, there's a lot of legal questions concerning sort of indefinite detention of immigrants who are in this posture with the federal government. So there are other cases also recently involving Asian Americans where the question is really like how, okay, federal government, you have plenary power in immigration, but how long can you detain immigrants before you act to remove them? Can it just go on forever? And there's real concerns about that many immigrants are picked up on crimes, some of them not very major crimes, and then they're detained for months and years, where there's really very few guardrails as to what needs to happen to ensure that you're being treated fairly and that you're not just basically thrown in prison or in jail indefinitely while you're in this posture of waiting to be possibly removed from the country. So lots of action. A lot of these cases involve Asian Americans in the country, and I just wanted to sort of juxtapose that early case in the Chae Champing with the Chae Champing case with this more recent case to show that for generations, our community has been involved in sort of defining what it means, what the terms of belonging to this country are, and how we've been excluded, historically over time in different contexts. So then moving on here, the next area, now the previous cases involved Asian Americans who are not citizens. Now we're going to talk a little bit more about Asian Americans and the rights of citizenship and what does that mean to be a citizenship. So here we have Wong Kim Ark, who was a Chinese American who was alleging that he was a citizen of the United States, and this was all the way back in the 19th century. So we move to the next slide. And you'll see that here that he was born in San Francisco in 1873. He's basically, today we understand intuitively that someone born in the United States is automatically a citizen of the United States under the US Constitution. This was the case that really established that principle. So we have the government alleging that even though he was born in the US, that he's basically Chinese, he's basically foreign. We look at his race, his language, his color, the way he dresses. And the government is making a very racialized argument that he is other, he is not American. And the US Supreme Court held here in this early case that no, in fact, he is a US citizen under the 14th Amendment of the Constitution. All persons born or naturalized in the United States are citizens of the United States and the states wherein they reside. So, even though we've had sort of these amazing setbacks as shown in the earlier cases, here we do have a 19th century case which is establishing a very important principle of a mechanism for becoming a citizen in this country is by virtue of being born in this country, even if your parents are not US citizens. So very important foundational case, and we'll see how that's used. This case has been important and used all the way up till the current moment as we turn to the next case, where we have a gentleman by the name of John Fitisemanu, who is born in American Samoa. And as we know, Pacific Islanders, American Samoans are not US citizens, even though they are living and residing and in many cases were born and raised in a US territory, that has not historically meant that you are a US citizen. And so Mr. Fitisemanu challenged this in court. We can turn to the next slide here. And he and two other plaintiffs argued that they are US citizens, and they used the Wong Kim Ark case to say that, yes, look at the Constitution. It says that if you're born in the US and that you should be a US citizen. And being born in the US means being born in a US state or a US territory, and that should apply and that we should be citizens. this court was litigated in the district court, so that you'll see up top there, it says D Utah 2020. That means the district level court in Utah. The court actually said that persons born in American Samoa are citizens of the United States by virtue of the citizenship clause of the 14th Amendment, which I read earlier. So this is really the Wong Kim Ark type case of our time. And it's still pending in federal court, in the appellate court, the next level up below the US Supreme Court. So this is by no means a completely settled issue yet legally. But we note how important it was for those foundational cases, Wong Kim Ark, that it made its way all the way up to disputes that are really still being, are still unsettled today, and still reflect a large segment of our community: Pacific Islanders, Puerto Ricans, those who are from the U.S. territories, which are acquired by the U.S. Through annexation, colonialization, our period of imperialization in this country, dating back to the 19th century and early 20th century. So this case, raises that struggle of second-class status of Pacific Islanders, those who don't have full rights of representation in our government, and do not have full voting rights, but who pay taxes and who are otherwise equal members of society, or ought to be. So this case really raises the fact that this question of how we belong and what our rights are and should we be entitled to citizenship, they're really live questions today that are still going on. You'll note here in the second bullet here of this slide that I made reference to the insular cases, which is really a series of federal US Supreme Court cases dating back to the turn of the 20th century, very early 20th century, where the Supreme Court was really addressing what are we going to do with all of the territories that we've acquired, the United States has acquired forcefully or through annexation, or in our expansionist and military exercises that we were going through to acquire territories following the conclusion of the Spanish-American War at the end of the 19th century. So this was the line of cases that the U.S. Supreme Court, in which the U.S. Supreme Court determined that there's sort of, no, the Constitution won't automatically apply to all the U.S. territories in the same way that they would apply to the United States and to citizens. And B, there's really a difference between these territories. Some territories that the U.S. have acquired are what we would call incorporated territories, like those that became states, like Alaska, like Hawaii. Others are unincorporated, and those are territories like Puerto Rico, like Guam, like the Philippines, the Mariana Island, Northern Mariana Islands, the U.S. Virgin Islands, and of course American Samoa. So these insular cases really established that that those cases, in those cases, and in the people living in those territories, that the Constitution does not automatically apply, and then there's going to have to be this sort of selective legal process where certain constitutional rights are afforded to those individuals in those territories. So we're still living under sort of the rulings from these insular cases and the sort of second tier status, if you will, that which is being experienced by the several hundreds of thousands, and in the case of Puerto Rico, millions of residents in those territories. And so the Fitisemanu case, let's see where it goes, because it might be something that really tries to sort of close that equity gap between citizens and non-citizens in a way that's very influential for Pacific Islanders in our country. So let's watch this case moving forward. And then I'm going to go to our third question here of what does racial equality mean? And we're going to explore that in the context, again, going back to some early cases in our US jurisprudential history. The first case I want to bring up is called the Yick Wo case, and this involves a Chinese person who and a facility in San Francisco. It was owned and managed by a Chinese American who was fined and imprisoned for violating a municipal ordinance in the city of San Francisco, and this was way back at the end of the 19th century. This depiction here, illustration here, is of a Chinese laundry in San Francisco, not too long before this case actually came about in 1870. So let's go to the next case and talk about it. Again, Lee Wick was the manager of this laundry facility in San Francisco. He managed a facility for 22 years, really, and there were thousands of Chinese American residents who were managing laundries across San Francisco and in California at the time. The San Francisco then happened to pass an ordinance saying nobody in running one of these laundry facilities can do so in a wooden building unless you apply for a permit. Okay, so, sounds good. It might be safety related. At the time, about 95% of the city's 320 laundries were operated in wooden buildings. About 2/3 of those laundries were owned by Chinese people. But although most of the city's wooden building laundry owners applied for a permit, only one permit was granted of the 200 applications from a Chinese owner, while virtually all the non-Chinese applicants were granted a permit. So there was this facially neutral ordinance about regulating the laundry structures and that had to be a wooden building, or you couldn't be a wooden building. But the way that this ordinance was applied and enforced went only to the detriment to the Chinese laundry facility owners and none to the white laundry facility owners. So Lee Wick challenged this in court, and it went all the way up to the US Supreme Court, and which sided on on behalf of the Yick Wo laundry facility and Lee Wick, saying that the administration of this ordinance was discriminatory. And it was one of the earliest cases establishing that we're not talking about a US citizen here, but that people in this country are still entitled to equal protection, even if you're not a US citizen. But beyond that, this case was really influential in the civil rights movement in this country overall and in the development of law around equal protection. By the 1950s, the Supreme Court was using the principle here established in Yick Wo to strike down attempts by states in the Deep South to limit the political rights of African Americans, for example. It's been used and cited in over 150 Supreme Court cases since it was decided way back in 1886. So it's really, it establishes a very important legal hook here. When you have a law or a provision that is facially neutral, it's not obviously discriminating on its face, but the effect of it when it's applied, when it's enforced, is discriminatory against a particular group of people by race, then that is also unlawful. That's a violation of our Constitution. And so you could see how important this type of law would be after the end of the Jim Crow era, for example, where governments could not explicitly discriminate or separate people by race, whether it's on the bus or in in a school or what have you. But if you apply neutral laws to the detriment of one community versus another, that's still unlawful. This case was a real foundational case to sort of establish that principle in our law. So then fast forward to perhaps the most famous case involving an Asian American in our country, and that is the Korematsu case. Here's a picture of Fred Korematsu I would imagine in the early 1940s. And the next picture involves him and his family also around that time. Who was Fred Korematsu? He was somebody who was, as we know, later interned by our government in an internment camp after the outbreak of World War II, because the government was rounding up people that it believed could be in collaboration with our enemies at the time, which was primarily, as it was enforced in this country, Japan, but also residents from Germany and Italy during the period of World War II. So if we go to the next slide, we'll see here that the President Roosevelt signed an executive order authorizing the removal of people of Japanese ancestry, and I put an asterisk there because it was also several thousand people who were of German and Italian origin as well, to basically proceed to a relocation center and into what we've come to know as internment camps. He was, just to underscore, he was a US citizen. And so the idea that we would be sort of summarily rounding up citizens and placing them in an internment camp, many people liken these to concentration camps. The idea that we would be doing that could seem astonishing to many of us today, but as we sort of fast forward to sort of things that are going on in our country around at the border now with the rounding up of Mexican immigrants and their families, maybe it's not so, it doesn't seem so foreign anymore, so distant in our past. We could also think about what's happening in Portland today with the rounding up of people by unmarked federal policemen and taking them to, who knows where. This idea of this kind of treatment is something that, yes, it's, we've come some ways since the Korematsu case, but in some ways, this case sort of makes us feel like, have we actually gone beyond this kind of behavior by the federal government? In any event, Korematsu challenged his confinement, race-based confinement in court. And on December 18, 1944, the Supreme Court upheld the confinement. It ruled against Korematsu, saying that actually we're in a time of there was a pressing public necessity around the time of World War II for the confinement of innocent individuals in this way. We're worried about espionage. We're worried about people who would not be loyal to the United States. And so it upheld Korematsu's confinement as well as all of the others who were also being confined at the time. And ironically, and sort of a bitter irony, this court established what has become known today as the strict scrutiny test for evaluating racial discrimination claims in court. The court said that, well, we're going to do this. We're going to allow you to these people to be basically imprisoned based on race for having done nothing wrong. But we know that to do so is not an easy thing. So we're going to say that in order for the government to discriminate in that way, you have got to pass a strict scrutiny test. There's got to be a compelling reason for the government to act in this way. And it's immediately suspect if the government sort of identifies somebody by race and wants to treat them differently based on that classification. So in some ways, this case it's just a bitter irony because it established a framework that has been used ever since to uphold the rights of disenfranchised racial minorities. But it was hatched in a case in which it denied the right in the most horrific way, that we can imagine. It allowed the imprisonment of people based on race who have done nothing wrong, and established the framework for evaluating all future race discrimination claims. So it's a very interesting case. It's very powerful for that reason. And I think justifiably, it's one of the most famous cases in all of law because of the shocking nature of what the government did to so many of those in our community at the time, and that this was upheld by the highest court in the land. So that's, I think, why it earns this dubious distinction as kind of one of the most famous cases involving the Asian American population. In a modern day case involving the Muslim ban that was enacted by the Trump administration in 2017 to keep out people of certain countries from the United States, largely Muslim countries from the United States. The court actually, in upholding the Muslim ban, President Trump's Muslim ban, and excluding people from this country based on race due to national security concerns. So very similar to Korematsu in many respects in what was going on, but the court explicitly struck down and overruled Korematsu in the Muslim ban case in 2017. And so again, but it's sort of repeating this phenomenon where it upholds something that many of us would argue is just unjust and unfair to people from countries based on national origin and maybe animus toward people who are of Muslim backgrounds. But then it sort of overruled Korematsu once and for all in doing so in that 2017 case. So some interesting parallels, I think, here between what happened in Korematsu and what's happening in the current moment with the Trump administration. The next cases are involving the education realm, and I'll go through these very quickly just to note what they are and their significance. In the education realm, we have a case, Lum versus Rice, that occurred in 1924. By way of context, segregation in the United States based on race in schooling, we have the twin cases of Plessy versus Ferguson and Brown versus Board of Education. This case landed just about in the middle of those two cases. So Plessy was, which said separate but equal is okay, was in 1896, and Brown versus Board of Education didn't happen until 1954. So here we have in 1924, the US Supreme Court upholding racial segregation in public schools as applied to Asian Americans. So Martha Lum, 9-year-old Chinese American, US citizen, was not allowed to attend a school that other white students were attending. And I'm just noting very quickly here, you'll see the quote. There was a lot of discussion about the parallels between white-black segregation and white, quote unquote, yellow segregation. And I sort of marveled in going through this case how many times the Supreme Court used the term yellow in sort of describing Martha Lum and Chinese Americans in general. And I was sort of wondering whether this popularization of this sort of the term yellow came from this case or maybe slightly before this case, but it's a very interesting and disturbing case where clearly the racist attitudes and the racialized perceptions of the court held sway and determined the outcome in part of this case. involving Martha Lum, along with reaffirming the now completely discredited case of Plessy versus Ferguson. So that was Lum versus Rice. A more recent application of the notion of equality, racial equality in public schools is represented by the Lau versus Nichols case. This involved a student who basically had been in the United States, living in San Francisco almost all his whole life, since the age of 5. When he came to the US with his mother, he spoke no English and basically entered the public school system, which failed almost completely to provide him with the language instruction skills that he would need, not only to learn English, but to learn other subjects, because how are you going to learn math? How are you going to learn science in schools when you don't know English, and there's no attempt being made to sort of educate you in your English skills, as well as those other subject matters in a language that you can understand. And so he challenged this denial of equal education in court. And the court here, they said that the school district violated, and this is a federal civil rights statute, going back to our earlier conversation, it violated the Civil Rights Act by not offering English learners or non-English speaking students with any programs to learn English and to receive a meaningful education. And this is one of the most influential cases in education today because it established the so-called Lau plans, where school districts have to really account for English learners and how they're going to be educated and come up with bilingual instruction or blended instruction, different ways to ensure that ELs receive a meaningful opportunity to receive instruction and that they can participate effectively in the instruction and curriculum in their public schools. So a very prominent case in the education field, and one that is, I think, still has a lot of influence today. The next education case is a little bit different, and this is the picture involving Harvard students and the issue of affirmative action. Very recently, I would say this picture was probably taken only a couple of years ago. And the case that we're going to discuss is Students for Fair Admissions versus Harvard, which, as we go to the next slide, we'll see this is a case that's still, it's now pending in the appellate court below the US Supreme Court, but it was the trial was conducted in district court in 2019. What's happened here was that this organization, Students for Fair Admissions, which included more than a dozen Asian American students who applied to Harvard and were rejected, this organization claimed that Harvard's discriminating against Asian American applicants and that this violates the Constitution. In 2019, the district court upheld Harvard's admission policies, saying that it was not racially discriminatory, or that its policies were consistent with other cases, which established that there is a way for race to be considered in some respects in admissions policies in colleges all over the United States. The interesting thing about this case, it involved Asian Americans who were saying that they were discriminated against. There was some indication in the evidence that Harvard was actually sort of giving Asian Americans lower scores than others on these subjective criteria that's sort of based on personality, like things like how likable are they as an applicant, how respected are they, how likable are they, how much courage or kindness do they exhibit as an applicant. And the litigation did reveal that the students who are Asian American were being scored lower than other applicants in that process. So in that evaluation process. So that was interesting to note. However, the court did uphold the policy, the way that Harvard selects students for admission, because as recently as 2016, in the Fisher case, the Supreme Court's case has said that you can recognize race in the in admissions policies if you follow this. Remember the Korematsu case? If you follow the strict scrutiny test and you have a compelling justification for a racial classification, it went on to hold other things like that your affirmative action admission policy has to be, the use of race has to be very narrowly tailored. It cannot be all-encompassing. You can't have racial quotas in admissions. And certainly you have to try race-neutral alternatives before going to the consideration of race explicitly in your admissions policy. So the district court did all of that. It upheld Harvard's admissions policies, but the case raises some important questions about Asian Americans and how they're treated in general, how they're viewed by universities. Is there something discriminatory in the way that they're being evaluated? But then also, what is the value of affirmative action, not only for Asian Americans, but for other so-called racial minorities? Is there a way in which affirmative action can and should still exist in schools, in part as a way to ensure that there is a diverse learning community at the higher education level? So very interesting case, a very interesting posturing of Asian Americans as plaintiffs in this case. There were also Asian Americans in the Harvard community and around the country that were bitterly opposed to what the Asian American students as plaintiffs were asserting in this case. Okay, and then finally, if we move to the last case that we're going to talk about here, I just had to put this case because it was an interesting one involving an Asian American band called the Slants, and immediately my eyebrows are sort of raised like, the Slants, what does that mean? This was a case that really dealt with in a realm of law called intellectual property, involved whether or not the Slants as a rock band should be given a trademark for that name, the Slants. They could get trademark protection so that could not be used by other people or other bands. And you'll automatically note that it sounds a little derogatory. So why is this Asian American band using and wanting to claim as a trademark the name the Slants? So if we go to the next slide, we'll show that there was one Simon Tam who was the founder of this group, and he really named his band the Slants because it was he wanted to sort of reclaim that slur, around Asian Americans having, I don't know, slanted eyes, let's say, and he wanted to take ownership of that stereotype and reclaim it. And so what he did was he applied for a trademark with the US Government Patent Office and Patent and Trademark Office. And he was denied that because the PTO was following a federal law that says that you can deny trademark protection for trademarks that are offensive or disparaging to a community in nature. So the PTO is proactively saying, no, we think that's a disparaging name. We're not going to give you a trademark. Well, Simon Tam sued, and the Supreme Court just a few years ago ruled in his favor and held that as a free speech matter, this was private free speech, by the way, that it said was being violated here, that the government could not ban Simon Tam's and the group's expression here merely because it deemed the term the Slants offensive. And so it was in some cases regarded as a free speech victory for not only the plaintiff here, but for many people, many others around the country who were trying to keep the government out of making determinations of what was offensive or not in the granting of intellectual property rights. And so there you have it. And this case raises interesting questions around what is free speech, what goes beyond free speech, what might be considered offensive or even discriminatory or harassing in nature, and is it okay for the government to be kind of sanctioning that sort of disparaging or offensive behavior through its awarding of patents and trademarks. On the other hand, does the context matter? It was an Asian American who was wanting the trademark. So does the context of why Simon Tam wanted to trademark this and why he named the band the way he did, does that matter? Does the type of offensiveness matter here? What if the band name had been the N-word, let's say, instead of an Asian American slur? Would it have been a slur against another racial group? And would that have been okay as well, even though that's offensive and some might argue that some slurs are even worse. So it's a very interesting case, and you know, I raise it here mostly because it was interesting and involved an actual stereotype or question of something that Asian Americans have experienced as discriminatory or harassing in nature. It sort of raised those types of themes, and it involved an Asian American. I thought it would be interesting to just raise that as one final case here. So broad takeaways and questions. Let me just say very briefly as we sort of summarize here, it's clear that these cases have been very influential, many of them, and are some of the most influential cases we have in jurisprudence. You'll notice that they all, I think, if we had to summarize or say, what are these, how do we tie these cases together? The issue of belonging is really prominent. Like, do we belong in the same schools as others? Do we belong in the workplace? Do we belong in this country? And I think, so I wanted to raise that as one possible common thread running through these cases. We've certainly have, as you've seen, noticed how race and citizenship come up over and over again, and how sort of basically this construct of race has been developed by and through the law to expand or curtail rights and privileges of people in this country. And then I raise a bunch of questions here, which we can sort of talk about, or you can ponder maybe on your own or with students if you develop these cases for use with students. You know, who's missing from these cases? There are many members of the AANHPI community who are not represented. And so maybe we should just ponder why that might be. Are there women, or issues involving Asian American, Native Hawaiian, and Pacific Islander women? Are they being raised in these cases? Maybe, I mean, I haven't, maybe one or two that we've mentioned, but I haven't, I think they're disproportionately male, involving male plaintiffs. So that's another question we might raise. Certainly we've seen, and I didn't have time, I think, to go through how much racism is embedded in a lot of these early cases, but there were a lot of racist attitudes exhibited by courts and judges. And I think, you know, if you aren't familiar with these cases and you go back and read them or look up the original language, you'd be shocked at sort of what some of the most prominent jurists are saying and what their attitudes were and how that shaped the nation, you know. And this goes, you know, from early cases all the way to fairly recent cases. And then certainly the questions are around where do these cases fit in the broader civil rights struggle and our history, and certainly how do they relate to issues that might be going on today in our society. And then finally, if we're thinking about how to teach these cases and whether they belong in a curriculum, where would they fit in our sort of our notion of what it means to teach social studies, what it means to teach history, what it means to teach civics. Should they belong in there more prominently? And if so, how would we introduce these cases and the principles in these cases to students of all age ranges and backgrounds? So those are the questions. Why don't we move on to observations? And hopefully this will sort of raise some thoughts or turn on some light bulbs about why they might be important to use with students. You know, first of all, they are stories and narratives of actual people. And I think that's really interesting to sort of think about and to that students might be very interested in what was going on with these people at the time that they raised the disputes they did, or at the times they were victimized by certain things happening in the country. So how can we raise up these stories and create more visibility in our curriculum? How can they really be used to counter stereotypes, like I was talking about at the beginning of this session, to sort of illuminate the full range of who our community is and what their issues are and have been in history? How can these opinions be used almost as historical artifacts that can be explored with students? You know, there's any number of ancillary materials that could be combined with these cases to sort of shed more light on what was life like for a Chinese American in the 19th century. How did those laborers in California, why were they in the United States, and what was their contribution? What was the discrimination and perceptions of others at that time? So certainly these opinions are historical in their own right and can be combined with other materials as well. How, you know, they really are a window into a whole branch of our government and how it operates. So I think, you know, as a civics matter, it's really interesting and valuable to explore what goes on in the judicial branch. They really do show how important it is for people to assert their rights when they don't have rights. And certainly these cases have shown how courts can enhance rights and really make people more equal. There certainly are setbacks, but there are advancements as well. And then finally, you know, as I've mentioned before, we see how we can be critical about the government. We can be critical about courts. We know that many of these cases were wrongly decided for wrong reasons. And I think there's some value in that, in teaching those principles and instilling that notion that just because our government's our government does not mean that we don't have to be vigilant and really a call for change when we think that something incorrect has been done by our government. So those are my observations about these cases, and let's go into how we might teach these with students. And here, I'll just raise 3 brief steps. Certainly, folks can contact me if you'd like sort of more tips on how to do each of these steps in greater detail. But really, if we're thinking about using legal cases involving AANHPIs in the curriculum, first we want to know how to find them. And I think one important thing to do is really to understand as educators that we know our students the best. We know who they are, what their experiences have been, and what their interests might be. So, you know, finding cases that relate to them or that could relate to them and that they might be interested in is, I think, one of the most important things. So step 1 is to do that, and then once we've considered that, we can then go to a trove of online websites that have these cases available to the public for free. I could name a few here, like there's OYES, there's landmarkcases.org, there's findlaw.com, there's Justia, justia.com, and there's certainly court websites as well, including the US Supreme Court website. Cases can be found and searched for in these free online websites, and so that should not be too difficult. But if you have trouble, ask a legal friend, send me a message, ask a law librarian, and I think you won't have that much trouble finding the actual materials that you're looking for. Step 2, though, is to really understand the legal texts and to prepare them for use with students. And I will be the first one to acknowledge here that it can be really tricky. Some of these cases are arcane. They almost are written in a way to make it as hard as possible to understand, with lots and lots of citations and sort of legalese, legal language. So I think it takes some practice to be able to absorb and interpret a judicial opinion as a non-lawyer, but many of them are fairly straightforward and are easy to understand. And all of them, I can guarantee you, get easier the more you do it, the more you sort of understand what are the important parts, what are the interesting parts to my students, what is the court really trying to say, what is the holding or the actual precedential ruling of the case. That gets easier, as any first-year law student will tell you, to do the more you familiarize yourself with cases in general. So, so this is a trickier step, but it can be done. And the cases that I've shared with you today, if you go back, you'll find that they are relatively they are dense, but they're relatively compelling and easy to understand in general as a historical document, really. So I really encourage you to get your feet wet in this and to pick a few cases. And then what you're going to want to do is prepare them for use with your students. And so many educators have a variety of different strategies to do this, but I think it really depends on the age and level of your reading level of your students, what you feel that they're ready for. The one thing I want to say here, without getting into how you might use a Supreme Court case with an elementary school student versus a high school student, the main thing that I think I want to encourage everyone to understand is that it is possible at a variety of different age levels and in a variety of different reading abilities and comprehension abilities. Some elementary teachers like to just describe a few concepts in the case, maybe tell the story themselves about what happened to a particular plaintiff, and then really go into some of the terminology. What does it mean to be equal? What in this case is unfair or fair, and why? And you know, having sat in on some of those sessions, it's amazing how young elementary students really get into the notion of fairness and what was at stake in this case and why was that fair or not fair. In the older grades, you could either paraphrase a case in a condensed or abridged format, or you could, you know, otherwise really adapt the case and use parts of the original language if it's a more advanced reading level. So there are a number of different ways to sort of adapt legal texts to the ability and interest of your students. And I think that was the point. The purpose of step 2 is that's what's, you know, going to be necessary to make these materials useful and accessible for your students. And then finally, number 3 is to really tie these cases into the concepts. You know, what are your goals around fostering respect and diversity and instilling some awareness of the concepts of equity and justice in your students. And so there's different strategies to do this, but really, I think, you know, a few initial suggestions are to really focus in on what was at stake in the case, what was the injustice, what was the differential treatment in the case, and maybe there's something similar in the lives of your students or in their backgrounds that they could relate to. If it's not a specific immigration issue, then it might be another example of unfairness, of how you were treated differently by an authority figure, and how that felt, how you experienced that. Maybe there's something at the school or community level in which there's a similar type of or related kind of injustice that your school could explore, that you could explore in these cases and sort of tie it into something a little bit broader that's going on in your classroom or your school. So those are my tips on how to make these cases come alive in your classroom. And I hope that this webinar has illuminated what some of the important cases are, why they're important, what the issues were at stake, and hopefully will motivate or give you some ideas for how these cases can come alive in your classroom and how Asian American, Native Hawaiian, and Pacific Islander people, important people in our history, can also be included in some way in your curriculum, in your teaching, and in your thinking. So thank you.
Bob, thank you so much. I am positively overwhelmed by all new information, and also I think new knowledge building on existing knowledge that I had about some of these Supreme Court cases, and just important moments in history that we should be knowing. I just encourage those who are watching this webinar, and thinking back to your slides with the takeaways and then the observations and tips, to really sit with those takeaways and those observations. I think that there's a lot of really rich information there that can be applied in multiple contexts. I also really appreciate two things. One, talking about elementary school. This can definitely be taught in elementary school. Fairness and unfairness is a very, very important topic to our future young leaders in elementary school currently. And I'm reminded of a brilliant saying I heard from a second grade teacher that we worked with a couple years ago, to start them young. It's possible to talk about very complicated topics at a young age. Start them young. And I think the second thing that I find very exciting is to stay vigilant, to constantly question, to dig a little bit deeper, but also to expand the story, to think about, how do these cases and plaintiffs impact a community, and how did those impacts reverberate across the country, but also around the world as well. I think that what you've presented for us is a much wider understanding of how far these court cases have reached in time, but also in history and geography. So I really appreciate you walking through everything here. Again, positively overwhelmed. Bob, thank you so much for doing this presentation. And for those watching, thank you so much for being here. If you'd like to see more talks in this series, please visit smithsonianapa.org/learn/not-to-stereotype. There you'll find more webinars breaking down various topics. And you'll also get to see Learning Lab collections, which will provide access to photos, archival materials, and links, such as the links that Bob referenced during his talk, and even more. We hope you stay tuned with us through the fall of 2020, where we'll be producing and publishing for free on this website a new activity book for teachers, breaking down the big questions and themes from this series.